Partner here at Altitude Community Law. I'm the head of our litigation department, and we're going to do our Ask the Experts a little bit differently this year, where it's just me and just kind of covenant enforcement, litigation, foreclosure type questions today. You can go ahead and put your questions into the question box, the little question mark on the left-hand side. You got to read a quick little introduction. So on your screen, you'll see just a little background with my face on it. There's usually a PowerPoint, but there's no PowerPoint here because we're just going to be answering your questions. Should also be a small box on the bottom right-hand side of the screen with the video feed. It's going to have me on it. On the left side of the menu, please select the question and answer icon and type all your questions there. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report and will be sent via email within 48 hours following the webinar. These credits are non-transferable. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. So with that being said, see if any of you guys have any questions. Again, if you look on your screen, there's a little question mark box. If you can type them in there, I will do my best to answer all of them as they come in. This is only an hour-long class, so it's relatively short. So again, I'll try and answer everything that we have. Looks like we have first question in. All right, so the first question is, how can HOA members encourage the HOA board to follow the covenants, and can they be sued? How can HOA members encourage the HOA board to follow the covenants? So if you have an association where the board is kind of actively choosing not to enforce the covenants, which I assume is what this question is about, what kind of steps can you either as the manager or the board do? One of the greatest steps to take is to talk about the liability of possibly the board. So if the board is acting outside of their scope and are choosing not to enforce things, one, it's opening up the association for possible litigation. Two, where it really comes into account is that typically everyone's getting along well, and then we all get that one homeowner who's a pain, nobody likes, and all of a sudden we now decide, okay, we're going to start enforcing against this individual. And once we haven't been enforcing against everyone, it's much more difficult to try and enforce against them. Now there's going to be an argument for selective enforcement. There's a possible argument that the covenants have been abandoned or a specific covenant has been abandoned. So really it's kind of the horror stories is the best way to try and convince the board that we have these covenants, we should be enforcing them. If we don't want to enforce them, then we should really be working on documents to get those changed. So that's kind of the basic one for that. Hopefully that answered your question, Karen. The next question, can you speak about non-enforcement government and how this sets precedent for an HOA? So this is kind of a follow-up. It's a good question. It follows up to Karen's question. So the question is, can you speak about non-enforcement of governing docs provisions and how this sets a precedent for an HOA? So precedent is, in terms of this, like you also hear kind of like grandfathering, things along those lines. The fact that when you usually hear it, it's that we have to settle a case for whatever reason, and the board is concerned that this is going to set a precedent. Everyone can do whatever they want now, something along those lines. And that's really not the case. So in most of your declarations, there's going to be a provision that talks about failure to enforce does not waive the covenants. So that's one way to show that this isn't a precedent. The other way that it's not a precedent is each situation is slightly different. So if the association has never enforced against sheds, and we have a community of 100 houses and there's 75 sheds, that's a big problem. More than likely that covenant has been abandoned at that stage, and now everyone can have sheds. If there's only 3 or 4, that's not a precedent, and the owner might be able to say, hey, these other people have it, I should be able to have it. But if it was a previous board that approved it or failed to enforce it, that's typically not going to move forward saying you can't enforce that same provision moving forward against other owners. They'll always make the fairness argument, but in terms of the law, we still have the ability to enforce that. So you're not really, the likelihood that you're ever going to waive or abandon a covenant is very small. But the bigger issue is that if you're only choosing to enforce when it becomes a problem, it's that problem owner, you're going to run into selective enforcement. So it's really a selective enforcement issue and not a precedent for the HOA. So hopefully that answered your question, Brad. Next question. What would unapproved irrigation updates fall under the 1-year rule for covenant enforcement in Kiowa? So when we're talking about the 1-year rule, we're talking about statute of limitations. And the statute of limitations for 1 year, it's 1 year of when the association knew or should have known of the improvement. And when the types of improvements that we're talking about are basically building or construction type improvements. So that would be something along the lines of building a shed or painting the fence the wrong color or painting your house the wrong color. It's not the same as a kind of a maintenance type issue where your house is already painted, but now it's faded and you need to fix it. The fading paint is not going to have a 1 year statute of limitations, while if they painted it the wrong color or put the wrong roof on, that would have a 1 year statute of limitations. So something that's permanent, like the irrigation system, you likely would only have a 1 year statute of limitations with that. Now, because it's underground, and depending on where they did it, you would have the possibility of making the argument that the association shouldn't have known or did not know about the improvement for a longer time period. So if the association knew it within that year and didn't do anything, didn't file the lawsuit within the year, and it's important to remember it's not just sending violation letters, it's actually filing the lawsuit within that 1 year time frame. But if it's something like that where we can show the association had no way of knowing, so say it was irrigation in their backyard, we obviously couldn't see that being done, the statute of limitations would be told until the association knew or should have known of what was going on. So that's kind of how the 1 year statute of limitations would work in that scenario. So depending on what it is we're talking about, Martha, more than likely the irrigation updates would fall under the 1 year statute of limitations. The issue is going to be, when did the association know or when should they have known? Next question. What jurisdiction does the HOA over backyard when not visible without trespassing in public streets? So this is from Rachel. I assume it's asking, what jurisdiction does the HOA have over backyard that's not visible without trespassing in public streets? So public streets is kind of always the big elephant in the room. The typical answer for a public street is that the association does not have the ability to enforce its governing documents or rules on a public street. There's going to be some caveat to that in terms of if the streets were dedicated after the declaration was adopted, and if that dedication says that the streets are subject to the declaration, then we may be able to enforce. That's a very, very rare scenario, but it's possible. The other issue is there is some case law, a line of cases that started in Missouri that talks about, basically it's a contract claim. And so they're saying, look, there's a greater community aspect here, and everyone knew when they were buying into it that they had to abide by the declaration rules, even over areas that the association does not own, such as the roads. We don't have any case law in Colorado that specifically addresses this. I think the safer approach and the more likely approach to be adopted by a court here in Colorado is that we are for open use of property. And since the association does not own the property, they can't create rules or enforce the covenant to say no parking on streets on a public street. So that's kind of the roundabout answer on that. In terms of backyards, so again, the association has a duty to enforce if it sees something or if it is reported to them. You don't have any obligation to go looking over people's fences and looking for those violations. But if the association is aware of it, then the association needs to be enforcing. Sometimes it gets a little tricky if such a thing is an improvement that's back there that would have a 1 year statute of limitations. So say they built a tiny shed that for whatever reason didn't go over the fence line, so there's no way for you to see it. And then a new neighbor moves in and they complain about this shed, but the shed's now been there for 5 years. The association could try to make the argument that there's no way that we could have known or should have known about this, and therefore the statute of limitations didn't start to run. However, that's a hard argument because we're going to spend our whole first part of the case trying to explain to the court that there's no way that the association could have seen this. There's no way we could have known about it. Therefore, we couldn't enforce about it. And then the second half of the process of our trial is we're going to have to try and convince the court, even though we never could have seen it, there's no way of knowing about it. It's now a really big deal, and the owner should have to remove it, even though it's been there for 5 years. So we kind of argue against ourselves in the first part of the case, saying there's no way we could have known it, and then trying to say, but this really is a big deal that you need to step in and require this owner to take it down. So that's kind of the problem with that, but that is how those two work. Next question is from Anonymous. Our property management company did not collect a resale closing fee per our declarations. $1,000 to be put into our reserve per resale. Do we have recourse? Has not been collected for several years and has been found by new board member. So, I mean, this is going to be your typical attorney answer in terms of it depends on what the documents say. It also depends on how many years ago it was. In theory, if the management company didn't collect the $1,000, it's possible they could have liability. Again, it's going to depend on your management contract with the association. It's also going to depend on how long ago it was and whether or not the provision in the declaration was even enforceable. So there's a lot of different sides to that. So in theory, it's possible they could have some type of damages. The association might have some type of damages against the management company, but it's going to be very fact specific. So you should take it to an attorney with the actual facts and have them give you an actual opinion. Unfortunately, with something like that, I can't give you anything other than general information here. But in theory, yes, it's possible that the management company could have some kind of liability for that. Again, remember the management company is the agent of the association. So it's going to depend on what your contract said between the management company and the association and whether or not that was something they were supposed to be doing and whether or not it's still collectible. This question is from Karoni Adams. The new continuing ed class says that allow family child care in the HOA. It says that this overrides the CCR. What if the building codes prohibit commercial activity, i.e. care center in the HOA? Does the new law override building codes as well? So the new law is specific to declarations. So it states that if a declaration has something in there that says commercial activity or specifically calls out a family child care, a licensed family child care, it has to be licensed. It says that is no longer valid and the owner is allowed to do it. Now, building codes, again, if you're talking about like city ordinances or something along those lines, that's going to be a city issue and not an HOA issue. So we wouldn't be enforcing that anyway. I would assume that the city would also deem either they'd give a waiver to allow it or they simply wouldn't enforce it based on the statute that's come through. So the short answer is yes, if someone has a licensed daycare, they're going to be allowed to have it in an HOA regardless of what the deck says. Whether or not the state or city would want to try and challenge that, maybe they could. But it's a little bit outside of my wheelhouse in terms of we don't enforce city code, obviously. So I don't know the specific answer to you for that. One thing to keep in mind with these child care centers is that they are allowed to have fences. So if your association is a fence-free association, more than likely you are going to have to make a accommodation to allow a fence for the safety of those children. So that's just one thing to keep in mind. Next question, Tim Bennett. When a resident reports a violation and a violation notice is sent to the violator, does the report, including the identity of the resident reporter and any backup such as video or other, become part of the violator's file such that they can view it if they so request? So this is always a bit of a tricky question, and some of it will depend, I guess, on what your enforcement policy states as to what they are able to see. Typically, you have your property file, this individual unit's file. A complaint is made, it would go in their file, and typically they would be able to see anything that's in there. That doesn't mean that you need to offer it up at the beginning, but I would say if the person who is being accused of violating a rule and the complaint has been made in writing, or if there is video evidence, they should be shown that so they have the ability to defend against it. Again, I don't think you have to proactively give it to them unless they request it. But if they request it, I think you'd have a hard time withholding it. One of the caveats of the record request and records under state statute is that if it were for someone else's unit, you don't have to disclose it. So if it's unit 20 that committed the alleged violation, and it's unit 22 that says, I want to see what was submitted against unit 20, the association does not need to turn any of that information over because it doesn't pertain to their unit. But if it's your own unit, you're entitled to see that information. And I think you'd have a issue with trying to go to court and say, look, we didn't show it to them, but here's all the information. And so they didn't have any ability to fix it because we didn't give them the proper information. So I would say, yes, you should turn it over if they so request. Next question, Deborah Troutman. If the HOA grandfathers or grants a waiver for a specific reason, best to also record with the county, correct? So lots of different things when you're dealing with a waiver. So grandfather is not a legal term. It's sometimes you'll see things that are written in where you might have a certain time period where things are allowed, but grandfathering is not actually like a legal term. In terms of granting a waiver, first you need to make sure the declaration allows for waivers. Sometimes it doesn't. Second, you need to see if it does allow for a waiver, who is allowed to grant a waiver. Is it coming from the DRC? Is it coming from the board? The next thing that you are going to be looking at is, it's going to depend, I guess, a little bit on what it is that's being waived, but typically we're going to advise against ever granting waivers. The only time that you would want to grant a waiver or a variance is if it is very specific to this property. So say you have a community that's set up, all the lots are squares, and it says that you need to have 2 trees in the front area. You have one lot that is pie-shaped, and the front of it comes to a point where it doesn't make any sense for there to be 2 trees in that front because it's such a small space. In that case, it would probably make sense to create a waiver for that home to say you only have to have 1 tree. And that's only going to apply to this property because it has such a uniqueness to it. So there's no requirement to record any of that with the county. Depending on what it is, I mean, you want to keep a record of it somewhere. So, and you want to make sure that record follows you from management company to management company or however it's going. So you definitely want to make sure there's a record of it. Recording a copy of it in the county, again, there's no need to do it. There's no legal reason to have to do it. My concern with actually doing it is, could it possibly be when that person is trying to sell or someone else refi or something like that, that they could say it's a cloud on the title. A title company could see it as a lien or something along those lines. So it'd be kind of interesting on how you would choose to record it. But you definitely want to make sure we keep a copy of it and that the management company and the board has the ability to access that even after there's a new board in or say a new management company. So again, I don't think I would recommend recording it in the county unless it's some type of a maintenance and indemnity agreement or something along those lines. But you do need to make sure we keep a copy of whatever has been granted or the board meeting minutes and make sure people know that if this issue comes up and a new board comes in and tries to find them, that we have the ability to show that this has already been approved. Next question. I have an HOA that paid to replace light fixtures that are the residents' responsibility. Is the HOA now responsible for these fixtures from here on out? So inside the declaration, there probably is some language that is going to talk about the association has the ability to take on additional responsibilities, etc. The simple fact of replacing the light fixtures, again, it's going to be a little bit specific as to how exactly it took place and if anything was said about maintenance. The declaration says that it is homeowner maintenance responsibility. The HOA, out of the goodness of their heart, chose to replace it this time. I think you could still turn back to the owner and say you're still responsible for maintenance. And if it has to be replaced at some time, you need to replace it unless the board chooses to replace all of them again. Again, it's going to be somewhat fact specific as to what letters went out to the association to tell them that this is what we're doing. But typically the declaration is still going to override that unless there's something that the association proactively did to say, yes, we're going to be maintaining, in addition to replacing these, we're going to be maintaining them. So again, kind of asking the civil attorney answer of it depends, but I don't think it's going to shift the responsibility simply because they chose to replace it. But there certainly is an argument for it. I think the association would win if challenged. Can a board refuse to deal with a member who is targeting other community members, board members, and contractors and management? What is the risk to the board if they refuse to take legal advice and telling the impacted person to just call the police? The actions are harassment, screaming, yelling racial and religious statements, sending about 20 emails a day, posting on social media. Okay, so a lot of issues going on here. So you can't just outright stop dealing with someone because they're mean or pain. We can, if they're sending 20 emails a day to the association and that is limiting the association's ability to properly function, we could certainly send some type of a letter saying, look, all of your emails are going to be received, they'll be read, but they're only going to be responded to once a month. And we'll send you a response to that once a month, and that's how we're going to deal with it. If you simply just ignore things that are coming in from an owner, that's going to be problematic for the association. The owners have the ability to gripe. They have the right to gripe. and the board needs to hear it and they need to address those concerns. Now, doing it all at one time is a lot easier than constantly having to deal with 20 emails a day. So I would suggest something along those lines where we send them a letter. You need to send them a letter and inform them of what's going on. Sometimes we have made it where they have to send all of their complaints via actual U.S. snail mail. So it comes in that way. So there are different ways that we can do to try and slow that down a little bit. If they are yelling at vendors or things along those lines, we can certainly send a cease and desist letter regarding those things. If they are yelling racial and religious statements, then you run into some of the FHA issues where this is not a neighbor-to-neighbor dispute. The association may have the ability to curtail this. So if they are harassing someone based on their racial, religious, or sexual preference, whatever it is, something that's a protected class, the association should be taking steps to try and stop this, either under the nuisance provision, but we certainly should be informing the person who's doing this that this is not okay, they shouldn't be doing it. Otherwise, the association runs the risk of being sued themselves for not enforcing harassment type things under the FHA. Can you clear up the difference between working sessions and meetings and the different open attendance and notification requirements for each? So this is really not a litigation type question. I can give you my best thought on this, and I would suggest you talk to one of our transactional attorneys here. But in my understanding, there is no such thing as a working session. I mean, it's a meeting. And so meetings are open to everyone. If there's something that needs to be confidential, then that needs to be an executive session, and you have to look at the statute to see what things can be talked about in an executive session. Otherwise, a working session is the same as a meeting. It should be open to everybody, and just like any other board meeting. Again, that's a little bit outside of my realm, but that would be my take on it as a litigator. But I would suggest you talk to Alina or David Furman or David Clausen or Melissa to get a better understanding of that, because it's a little outside of my purview and what this is for. Mary Hudson, isn't it best practice to give owners a 30-day review and comment period before enacting revised policies or rules and regulations? So Mary, the best practice is going to be follow whatever your policy says. So you're going to have an adoption of rules policy. Follow what that says. If it doesn't require a comment period, then there's no need to give a comment period. If it requires notice, then give notice. But ultimately follow whatever it is. There's no best practice. If the adoption of policies policy does not do what the board wants it to do, say it doesn't have any type of notice requirement or anything along those lines, and the board can simply just adopt it and then send out notice of the new rule, and the board doesn't like that, then I would say you should amend your adoption of policies policy to best fit what works for this association. But I don't think there's a one size fits all for that. Because sometimes, so if you have a 30-day review and comment period and your policy says you have to mail out this to everybody, and you have a 600 unit community, that's obviously a huge expense that might not make sense to the association. If it's a 7-home community, then it's obviously much easier to send out those mailings and have that comment. So that's it's going to depend. No one size fits all. So I would say follow your adoption of policy. And if you have questions or concerns of how that's doing, talk to your attorney and say, what is it can we do? What can we get better for this? Next question. Covenants talk about activity that would be an embarrassment to other owners. What's the standard or measure? So typically you're going to find this in the nuisance kind of provision. It's kind of a catch-all for everything. The standard or measure. So just like any kind of the other nuisance issues, it's not going to be one person's take on it. So it's not going to be my neighbor is cooking a bunch of Thai food and the smell is really bothering me, therefore that's an embarrassment, and you need to make this stop. If it's only affecting one person, then that's not going to be something that would be an embarrassment. If it is something that people normally do, but this person is hypersensitive to it, that's not going to be an embarrassment. If it's someone that is playing music at 11 o'clock at night and the sound ordinance says 10 o'clock, then I think we have a good claim for a nuisance type provision. Or if it's a person, we had one person doing naked yoga in the basically in a spot that people could see. That I think everyone would say is an embarrassment. And it's kind of the old case law of I don't know what pornography is. I don't know how to describe it, but I can tell you I've seen it once I've seen it. So it's going to depend on what the actual action is and whether it's something that is kind of globally thought to be embarrassing versus one or two people thinking it's an embarrassment. If your covenants only allow for sale signs and the occasional political sign in the yard, are security company signs allowed, i.e. ADT security? So typically things that are for safety purposes, so say like beware of dog or an ADT security sign, sometimes a no soliciting sign, we would typically say that because it's for safety reasons that you would allow it. The better process to go through is to adopt a policy that will help define that these things that are for safety purposes are going to be allowed as well. That's kind of the easiest way to deal with it. So oftentimes it's going to be no soliciting, obviously a security sign, and oftentimes like the beware of dog type sign. We would suggest that if your documents don't allow it, that more than likely we can create language that is in there that can deal with allowing such signs and limit them to the little 4x6 sign or whatever the size is. Next question, can you ask for a DNA on an ESA animal? And if they refuse to let the HOA get the DNA, what would the recourse be? So emotional support animals that are actual emotional support animals are not pets. So you can't do anything that is going to cost the owner of that ESA more money. So you can't make them pay a pet fee. If you're going to charge for the DNA, you can't do that. Simply registering the dog's DNA, I'd have to go actually look at the FHA and see if there's any cases regarding that. Because I mean, ultimately what we're saying is if the dog poops, I want to be able to determine whose poop it is. And we certainly have associations that do that. I've not come across an ESA having to get tested for that. But although they're an ESA and they're allowed, the owner still has to pick up after them. So just based on that, I don't think there would be an issue with asking them for the DNA. If they choose not to, then you get into a little bit more of a sticking point in terms of how are you going to try and enforce this? I mean, the ESA still gets to be there. Fines over that would be difficult. I would suggest I think that's going to need something that's going to have a little more research. So I would say if that's a legitimate issue that you're having, you should send that to your attorney and have them do a little research to determine whether or not you could actually, if there's any case law about the DNA for an ESA animal, because I'm not aware of any off the top of my head. Question by Donna. I have a president who was voted off a few months ago who sends me numerous emails about community concerns in the community. DRRs, landscape issues, board decisions, financials, etc. I respond with info I have and let her know I will respond after a board meeting with any new info as best I can. She refuses to attend meetings. 8 to 10 emails a month, sometimes a week. This homeowner doesn't always like my answers with information, so asks again and again. When am I allowed to consider this harassment? If I'm ever allowed to. So it's kind of like the earlier question that we had. I mean, ultimately, if what she is doing, it's not simply that, I mean, she's sending 8 to 10 a month, that's probably not going to rise the level of harassment. If she's sending 8 to 10 a day, then that is probably something that would rise to the level of harassment. You would want to, again, make sure you're only giving her information that is given to all the other members, nothing that's just meant for the board. And keep encouraging her to go to the meetings. I mean, if these are questions that can be resolved by the board meeting minutes, send her the last meeting minutes. But I don't think with how you're saying that it's only 8 to 10 a month, I think that would be hard pressed to say that that is harassment. It's certainly a pain to have to respond to those things, but I don't think that, I mean, 2 a week is something that would rise to the level of being harassment. If a board just found out that an owner made a change inside their condo a few years ago that is against the governing documents, does the 1-year statute rule come into play? Or would it be null at this point? Again, it's going to somewhat depend on what the work was that was done. Presumably, if it's on the inside, we're talking about some type of load-bearing wall or something along those lines. I don't know why else you would have, what other rules you would have that would be an issue. Maybe they put in a washing machine or something like that in a high-rise. The question is going to come down when the board should have known, when the association knew or should have known. So if she had construction workers going up and down into her unit, the association probably should have known. If there's no way for us to know, arguably the 1-year statute of limitations is not in play until we first find out about it. But again, that's something you're going to have to, with these ones like that, you're going to need to contact your attorney to get the actual facts and have them give an analysis as to whether or not. So it's possible that you'd be able to go after them. Now, if this is 10 years ago versus 2 years ago, that's going to affect the analysis a bit. And it's going to affect the analysis kind of what is the issue. But typically we don't get involved inside people's units. So it somewhat depend on what it is that's going on. Are owners entitled to inspect contracts, e.g. the property management contract, and do you recommend contracts be posted on the owner secure website? So per statute, the property management contract is something that an owner has the ability to see, as with any other contract that the association is currently entered into. So you don't have to show them proposed contracts or things along those lines, but any contract that has been entered into by the association is an association record, which all members have the ability to see. Recommend contracts be posted on the owner secure website. I mean, that's whether they're posted on the website it's up to the board. I think you probably have more issues with postings. You have more people looking through it and trying to pick them apart, as opposed to simply taking that extra step and asking you for them. If they do ask you for them, make sure you give it to them. But I don't think there's any need to put it up on the owner secure website. Does the HOA need a policy for ESA animals and DNA testing? So I would certainly say that we wouldn't call it an ESA animal policy, but if your association does not have a reasonable accommodation policy, which is what would allow ESA animals, or it helps set up the process so people know how they can get a reasonable accommodation, whether it's a ESA animal, whether it's a service animal, whether it's some other kind of accommodation. If we have an actual process that helps outline what these owners need to do in order to get approved if they have a disability, I would suggest all of your associations have that type of policy. If you have a overall policy for the association for DNA testing, I don't think you can just require it. You need to either needs to be in your rules and regulations, in a policy, or in the governing documents, the declaration, that DNA testing of animals is required. Again, I'll have to look back in terms of whether or not we can apply that to an ESA animal. But if you have a DNA, if your board wants to test DNA of animals, then they need to have a policy in place to do that. Adam Noel, if the statute of limitations has passed for a particular violation to be assessed, a type of fence, can the association require the homeowner to remove the fence when they sell? No. So once the statute of limitations is passed, the statute of limitations is passed, and it's as if it's been approved for all intents and purposes. There is no, until that fence comes down, there is no way to require the owner to remove it, even if they sell. It's already there. The association has lost its ability to enforce that. If owners are feuding and sending violations that can't be seen from the front yard, I am asking for photo proof. After sent, owner says they don't want violators shown the photo of the violation. Yeah, so if the owner is not willing to put this goes along with kind of the idea of we don't want anonymous complaints. If the owner is not that bothered by the violation to be able to put their name on it, then it should be an anonymous complaint. And under your enforcement policy, it's not really a complaint. We only take non-anonymous complaints because we have the person who's getting accused of this has to be able to know what it is they're being accused of and why. And so to have someone that said this and we have a photo of it, but we're not going to show you the photo of it, that doesn't work. So if the person is that bothered by whatever's going on in the backyard, they need to submit the photo to you, and they need to know that the owner is, if they ask for it, they're going to be able to see it. Can the violators dispute violations without the photo? Can the violators dispute violation without the photo? So again, so like when we're talking about these things, in order for us, once you have the violation and we send them first their courtesy notice and then however many fines, 3 fines, then turn it over to the attorney then sends a demand letter, and then we file a lawsuit and go to court. In order for us to prove what is going on, we're going to need to have that person who took the photo and who made the complaint, they're going to have to testify at that trial. If it's something that the manager themselves can inspect themselves, so if they can go see the violation and see it by themselves, then we don't need that owner anymore because now the manager has been able to see it. But if the manager can't see it, and the only way to do it is from that person's home and they're looking down, they're taking pictures, that's something that's going to be shown. And that's something that the owner who's being accused of the violation should be provided if they ask for it. If the board has not enforced a rule that requires owners to submit leases and allow the board to approve renters, can they now start to enforce this? Is this a fair housing violation in the first place? So the board has not enforced a rule that requires. So many associations have rules, either rules or covenants that require leases of rented units to be submitted to the management company. There's no problem with that. Sometimes it's hard to enforce, but there's no problem with that. If the board has not been enforcing it for years, before they start, just like with any covenant that has been around that the board hasn't been enforcing and they're now going to choose to force, I would always recommend sending out a community-wide email and put it in your newsletter, get it out anywhere you can. That, look, we understand that in the past we have not been cracking down on this specific provision. We are going to start cracking down on it. You have X amount of months, 2 months, 3 months to provide us with this lease. If it hasn't been provided within that time frame, we're going to move forward with our enforcement. That way they're on notice. You're giving them some time to get you the lease. And if they don't from there, well, they're in violation and we can move forward and attempt to go after them. Next question. I have a board member in a SFHOA, a single family HOA, whose home backs to the open space that is maintained by the association. His pet peeve is dogs running loose, unleashed in the open space, mostly in the presence of owners who are not always residents of the HOA. There is signage that leash laws must be followed, etc. But of course, those are ignored. Most of the time, the dogs are simply playing with their owners in the open space. And this particular board member is the only one who complains, and he's had a couple of confrontations with residents. For this reason, he is not well liked, but keeps pushing the enforcement. And I'm not sure what more management can enforce, especially if they're non-residents. And even when they are, I don't have any way to know their address unless they are followed home, which he has tried to do. Yeah, so I mean, so when you say leash laws, I don't know if the board has adopted rules that require leashes or if you're just talking about city rules. Again, the HOA does not enforce anything but its own governing documents. So its own rules, its own policies, its own declaration. If the HOA does not have any rules on this, then that's a city issue and his complaint should be to the city. If the association does have a leash rule in effect, then if you know who the person is, we know who the person is, then they should be given the covenant enforcement else. If he can't follow them home, which I mean, I wouldn't recommend someone following them home, but if he doesn't know who they are, there's nothing for the management company to do. If they are not members of the association, then again, there's nothing you can do. The owner could arguably call the police for trespassing, assuming you don't have to have no trespass on private property, but it certainly helps your case, and it's usually the only way the police will get involved. But that can be his other recourse, is he can call the police if it's a trespassing issue. Okay, next question. New treasurer, experienced professional of HOA board, is unhappy with the financial reports from the management company. Covenant requires a yearly audit, which hasn't been done ever by any previous board. Current board members refused to second and approve treasurer's motion for an audit. Treasurer is now resigned to protect himself. Recourse on rest of the board. So audit isn't really defined in Kiowa in terms of this. So it doesn't necessarily mean it has to be a professional audit. Oftentimes it'll just be a board member going through and making sure everything seems fine. If no one's doing anything to reconcile the books at all, that is probably problematic, and it's possible that the association could have liability. Moving that liability onto individual board members, I think would be a bit of a stretch unless an individual board member is doing something outside of that is wrong, like taking money. But I don't think the liability is probably pretty small. I would recommend, though, that they have some type of audit done, whether it's just the board member sitting down and going through all the financials to make sure things are adding up, or they pay someone to do a brief audit. But they probably should be doing something to make sure everything is reconciling. If a violator requests info regarding the reporting party, including videos, photos, names, doesn't that open the reporting party to retaliation, especially when they request to be anonymous? So they don't get to request to be anonymous. You either stand behind your complaint or you don't make the complaint. It's really that simple. Does it open them up to retaliation? Sure. If the owner does something that's a covenant violation or something along those lines, then the association needs to enforce on that as well. But ultimately, if you are going to complain about someone else, you need to stand behind that complaint and you need to not be anonymous. And that owner gets to know that it's you making the complaint. It is pretty simple in terms of that. Like the party who is making the complaint, unless it's something that the management company can verify themselves, needs to stand behind the complaint. Per an altitude laws document retention article, records of action taken without a meeting are required to be kept permanently. Please speak to your thoughts on how to document, store, and access by owners. Okay, so not really a litigation question. It's probably best dealt with by our transactional department as what the best practice is. But with everything being digital these days, I would assume that these meeting minutes are kept on a computer, and I would also assume that ideally you have a second backup in case that computer goes bad. So you have it stored in two places so that they can easily be transferred from management company to management company or board to board if need be. But that is how, in terms of access of owners, if it's a document that is an association record, then members are allowed to see it. And so the easiest way to get it to them is either, however they find it easiest, but oftentimes it's an email of a PDF. That's kind of my take on it. But if you're looking for more, I would suggest talking to our transactional team. I manage a townhome community where there was a leak in the walls between 4 units, which went undetected and therefore created mold. Per legal counsel in the governing documents, the homeowners were found responsible for repairs. The contractor is recommending to rebuild the firewalls, but also gave a quote for covering up the mitigated mold. Can the association require the homeowners to rebuild the firewalls, or is that not something they can enforce? So this is going to be a super technical question. And you also have to check to make sure whether or not that space between those walls is common element, which has, first you got to check to make sure there's any HOA responsibility. These water leaks are the worst. Oftentimes it starts on floor 4 and works its way down to the other 3 floors. Floor 1, 2, and 3 expect floor 4 to pay for all this because it initiated in his unit. How most of these declarations are going to be written, condominiums are going to be written. It's going to the damage that's inside the property or inside the unit, however unit is defined in your declaration. They're going to be responsible for those claims regardless where it started, unless unit 4 did something negligent, which is oftentimes hard to prove. So the short answer is, can the association require the homeowners to rebuild the firewalls? It's going to be document specific. You're going to have to ask that attorney for that same answer. I doubt that if there's a mediation process, just like the board can do it, and the person has a professional that's saying this is just as good as replacing it and a lot cheaper, I think the association would be hard pressed to be able to enforce requiring the firewall to go up. But again, it's going to depend on what your governing documents state. Next question: can you enforce city ordinance laws if those violations are not in the governing documents? So yes and no. So the only way you can enforce a city ordinance law is if the city has come in and enforced it themselves. So if the city has determined that you have violated a setback or you have violated some fire code or whatever it is, and they issue a citation to the owner, under most of your declarations, there will be a provision that says you have to comply with all laws. So if they've already been given that violation, they've already been found guilty of it, then the association could also hit them with a covenant violation. However, the association does not have the ability to determine that they are in violation of those city ordinances. We don't get to determine that you have violated a city code. Only the city can do that. What is your advice for record retention of financial statements, balance sheets, and income statements? Again, this really isn't a litigation question, so I'm going to direct you on that one over to transactional for all these record retention types questions, and let them give you their best advice because it's really not my wheelhouse. What does Kiowa say regarding rental restrictions? Is there a month limit, i.e. 6 months, and does the FHA have a say in HOAs? I'm not talking short term at 30 days VRBO. So there's no rental restriction in Kiowa. The default is everyone has the ability to do with their property as they will unless there is a law or governing document contract that limits it. So if we have rental restrictions that are 3 months, some are 6 months, some are a year. Obviously, we have short-term rentals in terms of 30 days or less. But there's nothing in Kiowa that's going to say it has to be X amount of time. Sometimes we'll have a complete ban on all rentals. So there's all sorts of different ways you can deal with rentals. But Kiowa does not speak to a specific time frame. How does a manager handle noise complaints between two residents, each complaining about the other on a regular basis? So these are always hard, these neighbor-to-neighbor disputes. One, the first thing is typically we say send both of them letters, talk about being a good neighbor, etc. But then if they are continuing to do this, get some type of proof, whether they're calling the police and we have a police report. There's apps on your phone where you can record the decibel level, something that the association has the ability to show that there is actual noise going on and this noise is not happening at a normal hour. So if it's happening, obviously if someone is making noise at 8 o'clock at night or in the morning, that's different than someone making noise at 2 o'clock in the morning. So it's all kind of dependent upon what the issues are. But one, we should do something. The board should send a letter to both owners saying we got this violation, blah, blah, blah. But then also we should be asking from the complaining parties, both of them in this case, that we need some more evidence to show that there is actually a violation going on. So we need either noise complaints from the police, we need decibel level, something, or recordings on your phones that we can hear that this is what's going on. They're jumping on the floor, we can hear it. We need some kind of empirical proof to help show that this is actually more than just someone living in their unit that's bothering you. Can you talk about proxies for voting rights? So the proxy question, again, is not really a litigation question. I'm going to have you go check with transactional. But typically proxies are allowed. And the default, if our governing docs do not specify, have a provision for proxies, are we still required to allow them to be submitted? So under the nonprofit code, proxies are still going to be allowed. That's my best understanding. But again, I would confirm that with our transactional department. Can the HOA take any other actions from a cease and desist letter to an aggressive, harassing, borderline violent owner in a multi-building unit? Mainly to protect the other residents and managing agent. And take any other actions aside from a cease and desist letter. So, I mean, yeah, just like any covenant violation, you go through your covenant policy. So if someone is being aggressive, and that's going to be a violation of their declaration, there's going to be a nuisance provision in there, depending on what their actual behavior is. But if you go through that process, and the next step is you go through the warning letter, the 3 fine letters, depending on how aggressive this behavior is or how bad it is. And depending on who drafted your enforcement policy, you may have the ability to deviate from your enforcement policy and send it over to the attorney quicker. But the attorney's action is going to be to send a demand letter telling them to stop. Then the next step is to go get a lawsuit, get a court order to require them to stop this behavior. Now, if the behavior is really bad and it's actually threatening, then whoever's being threatened would have the ability to go and get a protective order. And go through those steps. So that's always another issue. So if there's actual imminent harm that is being threatened, then that is something that is always an option. You have to be the party that's being imminently threatened. So there are some issues with that. But if it's really rising to that level, then you should talk to your attorney and have them talk to you about whether or not you can get a restraining order. But other than that, you should treat it like a covenant violation, any other type of noise issue or nuisance issue, and deal with it that way. If a community has a restrictive breed policy, can that apply to an ESA? So nope. So the breed policy would not apply to an emotional support animal. You can't limit it based on breed. They would need a reasonable accommodation to that policy. How does one deal with the issue of ESA letters from online doctors that have only seen the patient one time and it clearly is just being paid for the ESA letter? So this is always a problem. First, us as managers, you as managers, us as attorneys, the board, we aren't qualified to determine whether or not a doctor has spent enough time with someone to determine whether or not they believe that an ESA is required. Now, if this is an issue where it's truly someone online, the person's from California, doesn't have a medical license here in Colorado, we sometimes will push back a little bit on that and ask them to get one from someone in Colorado. But if they get it from Colorado, and look, especially nowadays, a lot of people are doing telehealth. Like our law firm, we have telehealth options. I can call into the doctor or do a Zoom call like this. So the fact that it's telehealth is not necessarily an issue. If it is there are certain spots, you have some case law, different articles that are written of like, these are really just those turn of the mill. All you have to do is submit this form and they pump out a doctor letter. Those ones we will push back on. But Again, anytime you get a reasonable accommodation letter, one, ideally you have a reasonable accommodation policy, but two, you should be submitting that to your attorney to review and get their opinion on any ESA letter, because there's just so much liability that goes into when you're dealing with the FHA. How do you handle a homeowner in a multifamily complex who constantly complains about noise, smells from units and buildings around? So part of it, when you move into a multifamily complex, there is some understanding that there's going to be noise. There's going to be noise. You're going to have smells, things like that. That is an understanding of when you bought this unit. Now, if it smells, especially if it's like a smoke, so if it's like cigarette smoke or something along those lines, one thing the association should do is look at anything that they own that might be able to deal with this. So maybe the AC unit or the ductwork, things like that. Oftentimes, if it's a smell issue or a smoke issue, we can, one, make sure everything's sealed. That's association responsibility. And then two, oftentimes it could be, we've had people just put a fan, associations put a fan in one of these things because it's all coming through one area and they can blow it back the other way. So there are things that the association can do with that. First step, though, is to make sure that the maintenance that is the association's responsibility is all taking place and taken care of in good working order. In terms of noise, again, it's going to depend on when it is. If it's during normal hours between probably 7 a.m. and 10 p.m., there's not a whole lot you can do about it. If they're blaring music or something along those lines, then maybe we have an issue, but you need to be able to document what these complaints are. Ultimately, you need to just tell the owner, like, look, this is what is going on. If you provide us something that we can look at and say, okay, this is really something that's out of the ordinary, then we can treat this as a violation. But just you telling me that they're making too much noise and it's at a normal hour, that's not going to satisfy it. Does an ESA need to be disclosed prior to signed contract in a unit that does not allow pets by renters? If it is not disclosed by the EC agent, would the board have any recourse? Nope. So the ESA can be claimed at any time. This person could have had this dog for 2 years and never needed an ESA letter. And then they move in here and all of a sudden this association requires an ESA letter. But there's nothing that needs to be disclosed about this. This is an accommodation, federal law that is required. It does not matter when they provide the letter. If covenants don't allow temporary structures to be located on a homeowner's lot, can a garage be built to house the RV? So in here you say e.g. RVs as temporary structures. I don't think an RV is a temporary structure. Typically, when you're talking about temporary structure, it's something that's built. So I think the garage could be built. And if it's something that's collapsible, so if it's like a tent, something along those lines, that probably would be a temporary structure that would not be allowed. But if the governing documents allow for an outbuilding or a garage to be built and they submit to the DRC and the DRC approves it, then yes, you could have that's not going to be a temporary structure because it's going to be grounded to the ground, grounded to the land. So I don't think it would be a temporary structure depending on what they're putting in. But in theory, a garage for an RV is not going to be a temporary structure. Our association has recently received requests. Another ESA question. Okay. The only document received was a prescription from a family physician dated back in 2014 and a registration through My Service Animal. I have one more board member saying that the documents do not meet the requirements for ESA. Please advise. So again, ESA, you should send it to your attorney and have them review it. Based on what you're saying, I don't know what the prescription is for, but simply having, if it's a prescription for Ambien or something like that, or some anxiety medicine, that does not, that would not be able to show you that the emotional support animal is needed for this disability. So they need to be able to, there's basically 3 questions that you can ask. And again, you should have a reasonable accommodation policy in place because you need to be careful and you should contact your attorney before doing anything with these reasonable accommodations. But ultimately, the owner is going to need to provide proof of a disability. They don't need to tell us what the disability is, but we need proof, which would be coming from the doctor's note saying, yes, they're disabled. What is the reasonable accommodation I'm requesting? In this case, an emotional support animal. And what is the nexus between the two? So if I have allergies to dust, and which can be under the FHA a disability, and I'm saying I need an emotional support animal, there's no nexus between those two. That's not the same. Now, if I have anxiety and my doctor has prescribed an ESA to help with that anxiety in social situations, etc., that would have a nexus. So there's going to be more information you need. And again, before sending anything to that owner, I would highly recommend talking to your attorney. Wow, we only got 6 minutes left. All right, trying to get through all these. The problem with posting contracts on the portal is it has specifics on cost scope. So doesn't this then make it unfair for when a community goes out to bid for service? I know you paid the old company, blah, blah, 1K a month, managed 18 months, so now I come in just under. So you could redact it. You could redact the contract on the website, but if an owner asks for it, you're going to have to provide the whole contract. So again, I don't think there's any reason to put this contract on the website, but if an owner asks for it, you are required to turn that over. And if they choose to use that to try and get lower bids, then that's their prerogative. Is there anything an HOA can do about the number of people living in a single family home or how many cars a home can have on parking on a public street? So again, the public street we talked about already. There's not going to be anything you can do about the public street. Again, number of people living in a single family home. You see people, so single family gets confused a little bit in terms of what the meaning is, what the meaning of that is. Really what single family is talking about is the building code. This is a single family structure, not a multifamily structure. It's not dealing with the occupants inside of it. So limiting the amount of people in there, and sometimes you'll see people try to do it if they are not related, which can run afoul of the FHA depending on how it's written. But if you are going to allow me and my wife and my 4 kids to live there, so there's 6 of us, but you're going to say 5 unrelated people, no more than 5 unrelated people, I would say that's probably going to be a violation of the FHA, because you're discriminating based on the family. You're saying that because they're my biological children, I get to have them there. And then we start trying to define family. So say they're not my biological children. Say I've adopted 4 kids. So great. Do I not get to have them because we're not family? How did you define family? Maybe it's we're only common law married. We're not actually married. Does that mean we're not a family? We're not legally married. So there are all these things. So it's a real slippery slope. And the short answer is probably not. The cities oftentimes will have a similar language of not allowing 5 or more unrelated people, and they might have a better chance of trying to enforce it. But typically I would say it's not the association's role to be dealing with something like that. Same thing comes into group homes when group homes get to come in, et cetera. Whether it's a drug rehab or whether it's a old person home, there's nothing really an association can do to stop group homes from coming in. An ESA certification is irrelevant in terms of the association. It's literally just an online notice. There is no such thing as an ESA certification. Support animals do have to have a license, a service animal, excuse me, not support animal. Service animals are going to be trained. They don't have to have a license, but they have to be trained for a specific task. So oftentimes when you're dealing with service animals, there's really no doubt that there is a disability. When you're dealing with support animals, it's much more likely to get a certificate on a support animal because they can just go get them offline. But that doesn't help us determine whether or not the owner is disabled and what the disability is and what is the nexus between that disability and the dog. So the ESA certification is not very helpful. Does every state require vehicle expiration tags? The association tags vehicles that are expired. We had a situation where there had been an out-of-state renter in the HOA with no expiration sticker. Is it all right to go ahead and tag tow according to our policy? I have absolutely no idea if every state requires tags. I would assume they do, but I have absolutely no idea. I will tell you, typically towing a vehicle is the quickest way for an association to get sued. So make sure, I would contact your attorney and actually go through this, but it's one of the fastest ways that associations get sued is once they tow someone's vehicle and the person has to pay $600 to get it back. Is it a good idea for our architectural committee to do regular surveys to look for changes that may be in violation of architectural guidelines in order to catch changes before the 1-year limitation on enforcement? So yes, I would say it's always good for the management company or the architectural committee or the board to walk the neighborhood and see if they see anything that looks out of place on a regular basis. I mean, typically most management companies are driving through and doing some sort of thing. ACCs can also do it. Doesn't matter who's doing it, but yes, I do think it is beneficial to be doing those on a regular basis. Can an HOA require an ESA to be licensed with the city? Example, Boulder Dog license. No, again, that's the city's issue. So if they aren't licensed with them, it's for the city to enforce, not the association. That's with any dog, not just an ESA. And so I certainly wouldn't do it with an ESA, and I wouldn't do it with a regular dog either, because again, you're trying to enforce someone someone else's rule. That's not your rule. You don't get to determine that this dog had to be licensed. That's the city's job to enforce that. Can a sub-association enforce a covenant that is not listed in their documents but is addressed in the master documents? So the sub-association can only enforce its own documents. Does not get to enforce city documents, doesn't get to enforce the master document. It only enforces their declaration. If the master is not doing that, then you need to take it up with the master, and you can try and threaten them, things along those lines, with they're not doing what they're supposed to be doing, and we might bring a lawsuit. But it's up to each association to enforce its own declaration. How does the board enforce? All right, I'm gonna take 2 more questions since we're at 1 o'clock, so I can respect all of your time. Let's see, do we have anything that is new? Something that we haven't talked about. How does the board enforce it? So this question we've talked about a little bit, but how does the board enforce their no street parking rule that is listed in the declaration? However, the association does not own the streets. Ultimately, it would just be like if there is a different provision in the declaration that said no African Americans can live here, no women can own property here. It's a rule that is not enforceable. It's a covenant, even though it's in there, it's an unenforceable covenant. So you cannot enforce it short of very specific circumstances. Can a board person allow the board? All right, take this as the last one. We had a stabbing and the police came and talked to everyone. The incident was on a Ring doorbell and the police took the video. The homeowner who provided the evidence was stabbed, then had the culprit return to the unit minutes after the police were on site. One, this is just an interesting question. The homeowner is asking the HOA to take action. I do not have it in the government documents to evict, and the police refuse to arrest anyone due to COVID. What can be done? Okay, so typically you're not going to have language that's going to allow you to evict, and even that, it's going to be a long process. So ultimately, it's going to have to be, you're going to be going through your covenant enforcement policy. So presumably, I mean, look, there's awfully for health and safety. The issue with this is it's a one-time thing. So you can send that letter, and if they do something again, then it might be a second violation. But other than that, if the police aren't doing anything, the association, we don't provide safety. We enforce our rules. We aren't there to provide safety, which is what kind of got in trouble back with the case down in Florida years ago, where the HOA got brought in because they had a neighborhood watch program that was sanctioned by the association. We don't ensure people's safety. We simply enforce our governing documents. So more than likely, there's probably nothing you can do. I would send that violation letter. So in case there's any other violent acts or any other issues that you can bring up, but there's nothing that you could probably do to be able to evict them. All right, with that, guys, I apologize for not getting to all your answers. You guys had a lot of great ones, a lot of questions. Hopefully this was helpful to you. Please feel free to reach out to any of us with additional questions that you might have. And I hope you guys have a great rest of your Thursday. Thank you.